I'm not really sure how helpful this evidence actually is when it's on photo. It's not putting in any new photos. It's just trying to say, and certainly in circumstances where there's not going to be any cross-examination, so trying to decide whether photos are manipulated or not. I mean, it's a very serious thing to find without Mr. President being cross-examined, without hearing from Mr. Keane. I'm just not sure it's a finding I'd be terribly enthusiastic about trying to make on the papers in the absence of cross-examination.
We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
If you enlarge it 400 times and it shows a greater degree of damage, then what your point is, when you look at this in close-up, you see there's a lot more detail, a lot more damage than was in the original photo. Seems to be the point you're making.
Please be seated. The High Court is now open for the matter between Joden Finance Limited and the Auckland High Court and the matter.
May it please the court be for the applicant. I have a memorandum that I've handed up to the court. Take more reading on it.
Okay.
Please, Your Honour, Counsel's name is Mrs. Kiwibank. I appear for the second respondent, Mr. President.
Thank you, Mrs. Kiwibank. Okay, Mr. Beard.
Your Honour, the second respondent has an interlocutory application. Will we deal with that first, or?
And in your hands, is this to do with the evidence?
Yes.
Right, okay.
Or should we go straight to the...
No, happy to deal with that. That first. Okay, so that's, well, it's essentially you're wanting to admit new evidence on appeal, is that right?
That's correct.
Or not on appeal,
not
under review.
Under review. Our position is that the decision maker was materially influenced by incorrect information.
Right, okay, but it's the, it's the second respondent's application to strike out your affidavit, is it?
That's correct. It's to strike out Mr. King's affidavit, and Mr. King is actually at the back of the court today.
Right. Okay, well then I better hear from Mrs. Boyer on that first then.
That's not, please.
Thank you, ma'am. Now, did the court receive the supplementary submission regarding the strikeout? They were filed at the same time as the synopsis of submissions.
So that submissions of second respondent in support of interlocutory application for order striking out.
Yes, ma'am. To be quite brief, and I will just address those. The legal burden of proof on the applicant in a judicial review is to prove both the facts giving rise to the grounds of review and the justification for the court to exercise its discretion. The court retains an inherent jurisdiction to strike out irrelevant or inadmissible content in affidavit evidence. Your Honour, Mr. Beard, my friend today, has framed the matter as perhaps an application to admit Mr. King's evidence.
No, I think I asked that. I think it's your application to strike out.
It is, ma'am. So Mr. King's affidavit has been filed, and it is our application to strike out that evidence. Affidavit evidence would result in, if affidavit evidence would result in potential for a substantial loss of focus and considerable expansion of the case outside its proper limits, it should be excluded. Now, before we can consider the specific evidence, we must touch on the grounds of review and judicial review in this case, to see whether the affidavit can be said to be relevant. So there will be some crossover with my submissions later, but I will just touch on the three grounds of review that the applicant has filed the judicial review on the basis of. The first is error of law, and that the interpretation in the District Court of Section 21C of the Consumer Guarantees Act was an error of law. The second is an error of fact, and that the applicant asserts the District Court's finding that the damage to the vehicle in question was minor, and this also incorporates the applicant's assertion that the District Court failed to consider the new evidence, which has been admitted for the purposes of judicial review today, which is alleged to show more substantial damage. And the last ground is unreasonableness. In the course of the District Court appeal, the applicant made an application to adduce further evidence. This was photographs of the vehicle taken by Mr. Murphy, the director of the Joden Finance. This application was opposed in the District Court, and Judge Harrison dismissed the application, giving oral reasons on the 13th of February 2020. The applicant has applied to adduce the same evidence for the purposes of judicial review, and His Honour Justice Palmer has admitted that evidence after an interlocutory hearing in this court. And I give that background as way of context for Mr. Keen's evidence, because Mr. Keen's affidavit has been filed. He purports to be an expert in detecting digital modifications to images and video production. Now, putting aside the question of whether Mr. Keen ought to qualify as an expert or not, the thrust of Mr. Keen's evidence appears to be his opinion as to whether the original photographs produced in the tribunal were modified or altered in any way when comparing them to the new evidence that has been admitted for this purpose in judicial review today. It is Counsel's submission that this opinion evidence is not relevant when considering the matters before this court with reference to the grounds for judicial review. This was not evidence before the District Court. No application has been made to reduce the evidence for this purpose. But most importantly, the evidence, the opinion, the comment, is simply not relevant to the grounds for judicial review today. Counsel submits that Mr. Keen's evidence cannot be relevant to any analysis regarding an error of law in relation to the ground for error of fact. This evidence was not before the District Court or even in existence at that time, and it cannot be relevant for the assessment of judicial review of error of fact. Mr. Murphy's new photographs and new evidence in themselves are, in counsel's submission, only relevant to the extent this evidence relates to the assessment of whether the decision maker fails to take into account relevant considerations. Indeed, the court, Justice Palmer, has directed the evidence should be admitted for that purpose, namely to assist in assessing the decision of Judge Harrison not to admit the evidence in the District Court. Any purported opinion about the nature of the original photographs produced by Mr. Purcell, or comparison with the now admitted new evidence, which was not before Judge Harrison in the District Court, simply cannot be relevant to the judicial review before this court. Such evidence would expand the case beyond its proper limits, and it is for these reasons that counsel submits Mr. Keen's affidavit should be struck out and not read for this review.
Okay, thank you for that. Mr. Beard.
As the court pleases. Your Honour, if I may, the crux of my learned friend's application is at paragraph 12 of the memorandum dated 23rd of November 2020, where it alleges that Mr. King's evidence is irrelevant when considering the matters before the Court of Judicial...
So, sorry, what are you referring to?
The memorandum dated 23rd of November from Ms. Riala, and that is...
Okay.
Yep.
Okay, so in paragraph
12. It alleges that Mr. King's evidence is irrelevant when considering the matters before the Court for Judicial Review with reference to the statement of claim. However, at paragraph 13 of the actual strikeout application, the second respondent pleads that the fresh evidence is only relevant to whether the decision maker failed to take into account relevant considerations. That is incorrect. The applicant has also submitted that the decision maker was materially influenced by the wrong information. Mr. King's evidence correlates with the vehicle being driven at such great force towards a concrete curb as to blow the tyre and damage the wheel and body. At CB 459, the common bundle, Exhibit P.
Yeah, understand that. Sorry, what are we looking at?
CB 459. And that's the affidavit of King, and I'm taking you to an exhibit. Yes. There's clearly a piece damage to the bumper and a piece of metal sticking out of the vehicle. And there's other photographs in...
So what do you say that photo shows?
It shows a piece of chrome. It shows damage to the front bumper and a piece of chrome sticking out.
Is there a photo of this from further back?
Yes, that's also in Mr. Murphy's, I believe. But then when we go to Exhibit N, then it also shows more extensive damage to the tyres.
So whereabouts?
That's the page 457.
Right.
So moving on, paragraph 9 of the applicant's statement of claim sets out the applicant further contends that the damage was not at any rate minor, and the damage caused by the second respondent's parking accident was careless or reckless, such that it could not be considered damage attributed to ordinary wear and tear.
So just pause. The key thrust of Mr. King's evidence, as I understand it, is he's not putting in new photos. He's trying the key thrust, or the key point of his evidence is to try and say that the original photos were manipulated.
Precisely, Your Honour.
Right, and how's that going to be substantially helpful?
It reinforces the theory of Mr. Murphy's case, which throughout the disputes tribunal transcript, Mr. Murphy has contested the evidence.
So has Mr. King put in any new photos of his own, or he's just analysing Mr. Murphy's photos and the other photos?
He's analysed and put those together in his exhibits.
How does, I'm just trying to figure out, how does that assist? I mean, as counsel, presumably you can point to the original photos, you can point to the new photos and say, the original photos show this, the new photos show this, there's clearly more damage in the new photos than the original photos. How's it substantially helpful to know whether those photos, and in the absence of any cross-examination of anybody, for me to try and determine whether photos have been manipulated or not. I mean, if there are new photos, which have been admitted, as I understand, showing significantly more damage, then presumably you go to the new photos and say, well, no, here's photos showing that the damage was greater than the district court was led to believe. Whether or not the original photos were manipulated. I'm trying to just figure out why it's significant whether or not the original photos are manipulated.
Right. It's significant because that's all the information that the NVBT had at the time of the hearing on the 18th of July. Mr. Murphy never had access.
But whether they were manipulated or whether they just, whether they were not very clear, was the light or whatever, if you've got photos showing more damage, isn't that the key thing? I mean,
Mr. Murphy's, the ones that Mr. Murphy took with Mr.
And they're in.
Yes.
They're in, and they're, I think Justice Sarah Katz in, can't they? I'm just struggling to see why. I mean, and I'm not sure that I can make a finding on manipulation without. I think Mr. King's expertise on photo manipulation is questionable on the affidavit. B, he hasn't qualified himself as an expert in terms of the High Court rules to give opinion evidence. And C, I'm not really sure how helpful this evidence actually is when it's on photo. It's not putting in any new photos. It's just trying to say, and certainly in circumstances where there's not going to be any cross-examination. So trying to decide whether photos are manipulated or not. I mean, it's a very serious thing to find without Mr. President being cross-examined, without hearing from Mr. King. I'm just not sure it's a finding I'd be terribly enthusiastic about trying to make on the papers in the absence of cross-examination. And I'm just not sure that's going to be, determinative or substantially helpful. So that's what I'm struggling with.
Your Honour, there was one issue raised in Mr. Preslett's affidavit about the connection with the photographs and whether these were in fact the original photographs from the NVBT that Mr. King analysed. And I would say, insofar as his evidence is opinion, running it through a Microsoft Windows program, which is a fairly common program when you're reading of the affidavit, that would be a subjective process using software package rather than opinion.
Well, he's got no direct factual. He's not giving evidence of fact. He wasn't in the car when it hit the curb or anything.
No.
I mean, he's giving expert opinion evidence on whether these photos have been analysed or not. I mean, it's not factual evidence. I mean, it can only qualify for admission as expert opinion evidence. I mean, the opinion is whether these photographs have been manipulated or not. And to give opinion evidence, he's got to be qualified as an expert in this area. I mean, why don't you, just so I can help me decide whether it's substantially helpful or not, take me to a couple of the key examples where he says photos have been manipulated, and perhaps show me why this evidence is likely to be substantially helpful to me.
Okay, so Mr. King has used a program called Windows Picture Viewer and a zoom function to inspect the images and enlarge them 400%. He then took originals from and matched them to the sections of new images. So if we go to D and G exhibits on view image from D, and that's with the section enlarged on G.
Okay, so what I'd like to see is like an original image and a new image, so to highlight the point that the original one's been manipulated.
So we have Exhibit B goes with Exhibit I.
Okay, so is B an original?
B was a new image of the front left tyre.
So, yeah, I'd just like to see one that was before the tribunal that Mr. Preslip submitted, and then Mr. Keen's evidence as to why I should infer or find that photo was manipulated.
Ah, right. Your Honour, Exhibits H and I. Now, we do have further documentation, but Mr. Keen can't swear that in today, showing the email trail for these photographs from the Department of Justice, Lucianne Keen, from the MVDT file.
No, I mean, we're obviously limited to whatever is in his affidavit, so you've got to make submissions based on that.
So H and I, but these are old photos, I believe.
So H says new image.
Well, this is
Sorry, so H is a new image.
from Mr. Murphy's.
Yeah, so what I want, because the allegation is that the photos that Mr. Preslip submitted to the tribunal were manipulated to make them look not as serious. So what I'm looking for is for you to take me to one of Mr. Preslip's photos he submitted to the tribunal, and then Mr. Keen's enhanced photo or new image to compare, to show that the original one must have been manipulated.
May I just please confirm?
The ones I'm calling new image, the new ones I got.
That's the original one?
The ones called new image are the ones from the tribunal,
Right.
which I compared to the originals that John took.
Right, it's been clarified. The ones called new image are in fact the ones taken from the trial. And if we go to page 452,
Right.
that item that says new image 404, that is the picture that was at the MVDT hearing. And these other arrows going out are the analysis that Mr. King has performed using software, readily available software.
Right. Because those, I mean, we look at, can we go back in the common bundle somewhere and just find some of, can you take me where the photos are that were before the tribunal? So not the new photos, the photos that were in evidence before the tribunal.
Right. They are not in the common bundle. 19. Right.
So tab 19, the ones in there are the ones that were before the tribunal?
Yes. And here we have 160. We'll go with yes, image 160 would go with new image on page 452.
Okay, so there on 160 we can see that scraping and that bit of the tire there. Okay, and then if I go to 452, what is that?
Okay.
trying to show?
On 452, then there's various arrows going to sections of that wheel that have been enlarged 400 times using the program Mr. King refers to, and showing that the damage is relatively more significant than it appears on Mr. Preslip's photograph filed in the MVDT. Same evidence.
Right, so he's enlarged it 400 times.
Exactly.
Well, if it's been enlarged, I mean, how does that necessarily indicate? I mean, without saying it's been manipulated, I would have thought you'd say, well, we've enlarged them 400 times, and now you can see the damage more clearly, and it's more significant than it looks like in that original photo. I can understand that. I'm just not quite sure. I'm not sure why it matters whether it's manipulated or not. I mean, if you enlarge it 400 times and it shows a greater degree of damage, then what your point is, when you look at this in close-up, you see there's a lot more detail, a lot more damage than was in the original photo, seems to be the point you're making.
Yes, Your Honour, and that page 160 picture of the tyre is a very big picture, very clear, and you look at these smaller ones, how visible this damage is on 452 and the preceding pages.
So where's the original one again?
The original one is at 160.
Okay.
And it's a big full-page photo.
So I'm just having a wee look here. So there are three lots of photos submitted post hearing. Just trying to look. So the first lot is the first lot, and then so there's another photo submitted for tribunal at 165. Doesn't it look the same wheel there?
Yes.
And then 166, I assume that's the same wheel.
But also, Your Honour, if you look at 164, you can't see a piece of chrome sticking out of the vehicle where the bumper is, interestingly. As you can see at 451. And those
I can't see anything much in 164. It looks very dark to me, and lots of reflections.
But if Mr. Murphy took photos and Mr. King has exhibited that at 451, and if you look at that angle of the vehicle, at 451 there's this piece of chrome sticking out underneath the headlight where the bumper clips on.
Well, does that suggest the damage could have been done later?
Well, these
There's
photos
obviously various explanations for this, and in the absence of
photos-
cross-examination, I don't know what inferences.
Well, the photos from Mr. Murphy, he wasn't allowed to inspect the vehicle or take photographs until the 18th of October, well after the hearing. So he had no opportunity to identify the wrong information or be precise about it.
I can't even really see these programs together. Let's have a look at these.
Oh, at
photos.
451 on Exhibit H.
I mean, I just couldn't say what the significance of that. It looks to me like something that just could be clicked back in. It's just, without expert evidence, I just don't even know what that photo is how significant that is, but I should put a tag on it. But I'm just going back to look at these tyres. So are these all, that's the left, they're all the left rear, on 12 and 166 ones. Are they all photos of the same tyre?
The front left, yes.
Oh, so we've got, so the next two are actually
So if you look
back
at-
left, aren't they?
Sorry, Ryan.
So I'm looking at 166, 167, they're actually the back left tyre, those ones.
Right.
So it's the front left I need to be looking at, isn't it?
And 164, if you follow that line underneath the headlight on 164, and then you look at the one at 451, that's where that piece of metal in the bumper.
So your fundamental point, as I understand it, is that, because the damage you're saying is the front left tyre, is that right?
Yes, and
Is that the original photos don't show the damage to the front left don't accurately show the damage to the front left tyre.
Exactly. The photos Mr. President supplied don't show
Yeah, that's not damage.
all the body damage.
And where's Mr. Murphy's photos that and what about, I see there's reference to photos that Mr. Murphy took of the car when it was in his shop originally. Have they ever been produced?
No, Your Honour, I don't believe that any photos exist.
Apparently he sent an email to the tribunal saying he had some, but I don't know if they were ever produced. Perhaps they haven't been. But I saw reference somewhere in the papers. So where's Mr. Murphy's photos that he took? The ones that are have been admitted? They're at.
They will be in his application to reduce breach evidence, I imagine.
I think they're. There's a colour set in from 58 on, I think, aren't they?
Here we go, Mr. Murphy's ones, and they're showing the damage to lights as well, and also
Okay. So anything else you want to say about the evidence?
yes. I would submit that error of fact has always been an issue in this case. And
This is in terms of the application to strike out Mr. King's affidavit?
yes,
So
yes.
you're saying it's relevant?
It is relevant, and it's in the pleadings. I would also say it's in the transcript at CV 41, line 19. Mr. Murphy categorically states it's been damaged since he purchased it. Mr. Murphy has always raised that as an issue. Mr. Presslip at CV 46, 47 and 48. Yes, I understand what you mean now. Like sometime I park too close, so there's a car, hit low curve, not much to it. It implies it's more than one this has occurred. And then at Common Bundle 345, tab 26, minute of Walker J, and this High Court, the applicant confirms that the applicant pleads error of law or fact. I would say that the applicant has always contested the extent of damage to the vehicle, and the tribunal was influenced by materially wrong information and the wrong facts. The second respondent refused the applicant or his expert to allow an inspection of the vehicle prior to the MVD hearing. At CV 101, paragraph 5, Mr. Presslip proposes the hearing took place on 18th of July 2018. Then at CV 104, at paragraph 15, Mr. Presslip deposes that in early October his former lawyer consented to Mr. Murphy taking photographs. The additional photographs from Mr. Murphy were not available at the MVDT, and they show a different story. In fact, going back to the pleading, all paragraphs 9, 12, 13 involve error of fact or error of law. And I'll finish on what Justice Palmer said at Common Bundle 436, paragraph 4. The court has jurisdiction under the Evidence Act and its inherent jurisdiction to admit the evidence for the purpose of judicial review. If it is not, it is difficult to know how the court will assess the claim that the evidence was relevant and was an error for it not to be taken into account. I believe that Mr. King's evidence should be allowed in for this hearing, and Your Honour may like to make a determination if it follows.
So Justice Palmer's minutes, obviously, in relation to Mr. Murphy's evidence, I won't.
Your Honour, I don't see that Mr. King's evidence will upset or cause any great length to this hearing today. It's all on the documents. And if further clarification is sought on the source of where he got the photographs to analyse, we do have that, but we can't hold him to swear it in.
Okay, thank you. Anything else?
No.
Ms. Wayaba, anything in reply? Mrs. Wayaba, sorry.
Thank you, ma'am. Your Honour, I think we have to be very careful here. This is a judicial review, and we are looking at the processes of Judge Harrison, the District Court, when he determined the appeal of Joden's finance. Now, there was nothing that Justice has allowed the photographs of Mr. Murphy, and for that purpose, to see if there was any error committed by Judge Harrison. There was no discussion before the District Court, any allegations and manipulations. There was none of that discussion on the documents or in the hearing before the District Court. And I think Your Honour has grasped the issue where it really, this evidence is not going to substantially assist in assisting the court in determining the grounds for judicial review. The second respondent, counsel, was not, there was no, it was clear that the applicant pleads error of fact for judicial review. What counsel's submission is that there, and counsel will take on through this, is that there are issues which may prevent or may provide hurdles for the applicant to overcome in establishing that Judge Harrison even considered the facts in the District Court, that they were even a live issue. There was, you referred to the question of whether there were further photographs taken by Mr. Murphy. I think, just for your reference, ma'am, the email and the papers it was referring to is in the common bundle at page 180. This was the correspondence between the tribunal administrator and both the parties in the exchange of the further photographs provided post-hearing. So this ma'am is after the first directions, formally asking Mr. President to file photographs. Your Honour, the evidence Mr. President did that in hard copy, and so then the tribunal administrator has provided those to Mr. Murphy. Mr. Murphy then replies by email Friday, 19 July, page 180. Please show the adjudicated pics taken of the vehicle from when returned by customer for repair.
So who's he sending that email to?
Your Honour, he's sending that to, apologies, the chain is unclear, but
He's sending it to someone at the
he's sending it
tribunal.
to the tribunal assistant, like Lucy Ann Kennan.
Right.
And then a further email to Lucy Ann, these pics were taken after purchase. Then Lucy Ann, Ms. Kennan replies on behalf of the tribunal, the next page, 179. Good evening, Mr. Murphy. The only photographs on the file are the ones supplied by the purchase today. Please note there were no pictures attached to your recent email. So, Mum, that was the end of that line of thought. Mum, I don't believe any further photographs were admitted by Mr. Murphy, but in counsel's submission, and this was also produced before the District Court, it shows that Mr. Murphy actually had the ability to file photographs of his own at that time, and he chose not to. So, Mum, in conclusion, my final remarks would simply be to reiterate that Mr. Murphy's new photographs were admitted only for the purpose of determining whether Judge Harrison followed proper process and did not make any errors when disallowing that evidence. And Mr. King's affidavit evidence did not add anything to that assessment.
Okay, look, I have some real reservations about whether these new photos are admissible, but what I'm going to do is I'm going to admit them to be an essay provisionally for the purposes of today's hearing, and I will rule on their admissibility contemporaneously with the written judgment that I deliver on the substantive issues. Okay, so then I think that brings us, Mr. Beard, on to the substantive appeal.
Sure. Your Honour, it's the applicant's case that on the 30th of June 2020, the decision of the first respondent, the Auckland District Court, the decision of Harrison UCJ, to uphold the 2nd of April 2019 decision of the NBDT in Preslip and Joden Finance, allowing the second respondent to reject the Mercedes-Benz motor vehicle he purchased from the applicant should be set aside for the following reasons. Section 20...
Now, I should give you an indication, sorry, I should have done this before. I have read both parties' submissions, so you don't need to read them to me. I'm happy for you just to speak to them and explain what your key points are. I've actually read them both twice, so I'm reasonably familiar with them. So I'm happy for you to summarise your key arguments.
Okay. In synopsis, where I want to take you today, Your Honour, is once damage is substantiated under Section 21C of the Act, thereafter, the single judicial decision is whether or not the damage caused by the consumer was related to the vehicle's state or condition at the time of supply. That's the only question available. In this case, the decision maker was materially influenced by the wrong facts and not acting as Parliament intended, and Mr. Keen's affidavit relates to those wrong facts. The decision of Hanson and corresponding orders to uphold motor vehicle disputes should be set aside on both grounds of law and fact.
So, dealing first with the error of law, can you describe that for me in a nutshell?
Oh, I'm going to get there, Your Honour.
Well, can you just, before you get there, if you could do it now, that would be helpful.
The error of law, in terms of Section 20C, is a statutory interpretation argument that goes...
So do you say, I guess the key issue I'm trying to get to, do you say that, I understand the argument advanced previously was that really any damage precludes a right of return. Is that still the position, or are you saying there can be some degree of damage, or are you saying any damage at all?
Any damage at all, Your Honour, and that is the case law and Hansard that we have provided.
Right, so if that's the case, and this is, as I understand it, why Judge Harrison initially, he rejected the new evidence, because if the argument is that any damage at all precludes a right of return, there is damage showing on Mr. Preslip's photo. So whether it's, minor damage, major damage, if the legal position is that any damage precludes it, even on Mr. Preslip's photos, it clearly exceeds the any damage threshold. And as I understand it, that's why Judge Harrison didn't allow the new photos in, because in fact the argument as he understood it was any damage precludes a return.
And there we have it in a nutshell. They've all done, all these so-called learned friends have just danced around the head of a pin, when the fact is there's damage. Mr. Preslip freely admits that he rode up onto a concrete curb, but the part that they're missing is that the tribunal and Harrison both decided that the damage was due to ordinary wear and tear. Remember in the court case in June, You've got Anna and old Georgie, Gary, turning around and saying, oh, well, let's have a look at the Oxford Dictionary's, definition. And Anna left out the verb definition, which is anything that causes a loss. There's no way he could sell that car for the same price on the lot, even though old Judgy and Harrison decided, tried to sell that to him. He might as well try selling snow to an Eskimo, for Christ's sakes. Anyway, it's crazy. They're all dancing around the head of a pin. The facts are, the car's damaged. He loses his right to return. And he's just wasted hundreds of thousands of legal aid, your money, defending a private civil matter. How's that happen? See ya.
The vehicle, and it's common ground that the vehicle has been damaged.
Yes, Your Honour, but also he does make a distinction with minor damage, and he goes into it in that pre-qualification of what minor damage is.
So,
And there is no
would it be fair then to say that your argument is the starting point is as a matter of law, any damage precludes return?
Yes.
But if you're wrong on that, and that some degree of damage is permissible, that the degree of damage here exceeded what was permissible, essentially.
And that the tribunal didn't know the extent of the damage, but it's still damage. And where we've taken that authority from is we've gone to, right back, we've done a little bit of an investigation into the 1992 CGA electoral bill, and there's some interesting comments there about the purpose of the Act to protect consumers and facilitate business. Now I noticed in one of my learned friends' authorities, McBride Streetcars, Justice Elias, who admitted me 22 years ago, has said that facilitating business does not mean protecting consumers who conduct business foolishly or carelessly. And carelessly is the key word. Now, the CGA has the same purpose. Protection of consumers and facilitating business. And the CGA Hansard report goes a little bit further and talks about harmonisation with laws of Australia. And the Australian law in the Competition and Contracts Law Act is word for word identical to our section 21C. And the Australian courts have interpreted that section. Once damage is established, that's it, unless the damage relates to the previous reasons of rejection. That's the only question for judiciary. The second leg. The whole purpose of this Act was to tie New Zealand's business law with Australia's. It's said by Mr. Dunn, it's said by a host of politicians. Oh, I was waiting for you, right. So this motor vehicle was damaged after delivery to the second respondent for reasons not related to the motor vehicle's condition or state or condition at the time of supply on the 10th of February 2019. It's in the transcript, it's undeniable. The vehicle hit a concrete curb and was damaged. If you look at the Trade Practices Act 1975, it discusses abnormal usage. Both the MBDT and the first respondent made an error of law by interpreting that right to reject a vehicle under Section 18(3)A was not lost under Section 21C because the damage caused to the vehicle was minor. That is simply not an option and there is no discretion. The applicant submits that Section 21 of the Act to interpret in accordance with the meaning ascertained from the plain text of that provision, the purpose of the Act considered in light of the purpose of the Act as a whole, does not allow case-by-case exemption from Section 21C for minor damage, nor does the Act's Australian counterpart or the corresponding Australian cases.
Where are you in the submissions?
I'm summarising.
Oh, right, sorry, you sounded like you were reading from something else.
No, I have an annotated copy.
Oh, right, okay.
So this is a summary of the first respondent's finding of fact. The second respondent's damage to the motor vehicle was minor, was wrong at the time of the decision on the 30th of June 20, and wrong on the facts, substantiated by the fresh evidence now filed before this court. Notably, the first respondent would not accept such fresh evidence or take it into account, despite specifically noting that such fresh evidence may be relevant to the second respondent's right of rejection. So Judge Harrison acknowledged this evidence could be relevant.
That comes back to the point I made before, which is that he acknowledged it could be relevant, but because the focus, basically the error of law that was being argued before him was that any damage precluded return, and there clearly already on the evidence was damage, then determining the degree of damage, if that was the issue on appeal, was error of law and the interpretation of that Section 20C, then actually the degree of damage was not particularly relevant because the issue that was being advanced on appeal was that the degree of damage disclosed already precluded return, so there was no need to prove more damage because it was a legal issue. He was being asked to determine on the interpretation of that section. So that's how I interpreted his decision, is that yeah, it could be relevant if you were arguing about the extent of damage and whether this was more than fair wear and tear and whatever. But if your argument is that any damage precludes return, it's damaged. Everybody can see that it's damaged in the photos. So if the argument is black and white legal argument, it doesn't actually matter how much damage there is because it's already gone over the damage threshold.
Yes, Your Honour, where we were going was a qualification of minor, and that's where the whole extent of damage argument comes in, is the NBC.
But as I understood it, that wasn't the argument in the district court, that minor damage was okay, which was the district court ended up. The argument for today's appellant, your client, was that no damage, any damage at all. It was an absolute black and white, that there's no problem. Any damage meant that you lost your right of rejection.
Your Honour, that wasn't the sole thrust in that I would submit.
Right.
And
But that's still the argument here today.
That's the argument here today. But I would say there's enough in the transcript to suggest that's not the case from the disputes tribunal hearing.
You gotta like David sometimes. We don't have that transcript. Gosh, aren't we lucky that someone managed to keep a record of that hearing? See ya.
We don't have that transcript.
But is there anything there in the submissions or anything that suggests that the issues were broader than just that interpretation issue?
Not until we get to the minute of Justice Walker in High Court.
So really the issue on appeal in the district court was this legal issue. Does any damage at all preclude return?
An error of fact can cause an error of law, though.
Well, it could, but I'm just trying to see, if that was the sole issue in the district court, does any damage preclude a right of return? then when reviewing a judicial review of district court decision, don't we need to focus on that particular issue? Because that's the sole issue before the district court. Can we broaden that out then on judicial review?
I would say yes, Your Honour, of course. In particular, and I go back to Justice Palmer, and if we want to examine all the issues and close this off, then error of fact was always there.
Well, I mean, your client could have run a two-pronged attack in the district court. He could have said any damage at all precludes a right of return. But if I'm wrong on that and minor damage or ordinary wear and tear is permissible, then the damage in this case exceeded that threshold. I'm just not sure that is how he ran his argument.
And also that the damage that was, or the information on the damage that the NBDT and the district court, it was wrong. And those photographs show that.
I mean, because this obviously isn't an appeal. He doesn't have another right for appeal. This is a judicial review, so I have to focus very carefully on what was the issue, that was before the district court.
Your Honour, in the Fortis case, which was another Section 21C case, the car suffered minor damage. The vehicle was panel beaten, and the MBDT still eliminated the right to reject. And there's a number of other cases mentioned in our submissions towards the end that all endorse what is consistently called a harsh approach. But the Australians have found a way around that. So if I may go back to the submissions, I'm up to about paragraph 1.1.3, on which you're on the So, the applicant submits that fresh evidence substantiates that the second respondent misled and influenced both the MBDT and the first respondent as to the damage he admits causing to the vehicle. The motor vehicle was damaged after delivery to the consumer. The applicant says the damage caused to the vehicle is significant either way, such that the right to rejection under 18.3a of the Act was subject to and lost under Section 21C. And that's the key. Subject to 21C. In terms of fair wear and tear, the second respondent added 2,700 kilometres to mileage of the motor vehicle. The transcribed evidence before the first respondent was that the damage was caused by abnormal use, being the collision of such great force and impact against an immovable concrete object described by Mr. Preslip as a low curve that it caused an expensive tyre blowout, engraved scratches upon expensive mag wheels, and damaged the body of what is an old luxury motor vehicle, not a Dodgem. This first respondent erred in finding that the damage caused to the vehicle was consistent with ordinary wear and tear. And this is, again, points to Mr. King's photographs and Mr. Murphy's photographs of the bumpers and the wheels and the tail lamps. Front bumper hanging off, tail lamps, wheels. I believe Mr. Murphy submitted an affidavit that damage alarms 3,800 plus GST. And he was never allowed to look out at the vehicle to assess that damage before he had to refund. So, Your Honour, we're pre-hearing interlocutory applications and the pathway of this proceeding. At paragraph 4 of submissions, I would just add a paragraph that the affidavit of King clearly substantiates additional damage to the motor vehicle that was not available at the hearing of the EMBT. Now, paragraph 7 of the submissions, the applicant's evidence on judicial review.
The numbers of your submissions you're reading from don't appear to be the same as mine. I'm going to check with the document. So I've got applicant submissions dated 1 December 2020.
Yes, 1 December 2020.
We're at paragraph 7.
4.
Paragraph 4.
4. Paragraph 4, Your Honour, sorry.
So my paragraph 4 says the applicant relies on the record of the MBDT and the first respondent. Further relies on the affidavit dated evidence that goes by.
Yes, this is the evidence what my client is relying on. The primary record is the MBDT transcript. That's the most telling document. But he's also...
But it's a judicial review of the district court, isn't it? And the issues, no doubt, are much narrower at the district court than they are before the MBDT. So don't I have to focus a bit more on the district court because it's a judicial... the issues could have been very wide at the MBDT, but then it's gone up on appeal on certain grounds to the district court, and the challenges, it's judicial review, so it's the challenges, the process of the district court has gone wrong somewhere.
The process
which includes areas of law and so forth. And so I've really got to focus on what's happened in the district court.
well, the process of endorsing the MBDT judgment in itself.
Well, but it didn't. The whole lot didn't go up necessarily. There was quite a narrow issue that went up to the district court. So I mean, I've really got to focus on the process of determining the issue that was before the district court found us on.
Judge Harrison accepted all findings in the MBDT.
Yeah, but that's in the context of the issue he had to determine. So he wasn't asked to revisit all that. So, you know, as you often do on appeal, you say, okay, accept all that. This is the issue I need to determine. So we need to look at what was the issue he had to determine, and has something gone wrong in the way that he approached and determined the issue before.
Yes, Your Honour, minor damage and qualifications to section 21C in certain words that the legislation just wasn't elastic enough to accommodate.
No wiggle room.
So, Joden relying on John Patrick Murphy's affidavits, Lance Bell, Mark Joel, Eric King, but also there's the MBDT transcripts of what was said on the day at the hearing and by whom. Now, Your Honour, paragraph 6, facts arising prior to the MBDT proceeding. Do we need to recover that area?
No, I think I'm
Okay. Paragraph 9 there, the MBDT held that the applicant had failed to fix the problems with the vehicles in a reasonable time. Went on to consider whether Mr. Cresslip had lost the right to reject. Mr. Cresslip's oral evidence to the MBDT that was he had caused no damage to the vehicle after the time of supply, other than one of the vehicles went. And there is an excerpt of the transcript. Mr. Cresslip provided photos to the MBDT of the damaged vehicle. He did not provide photos of or disclose to the MBDT any other damage. On the basis of Mr. Cresslip's evidence, information, the MVDT was influenced and found that although Mr. Preslip had caused damage to the vehicle, not related to its condition at the time of supply, that damage was minor damage to the front left tyre and a minor scrape to the wheel. And that is insufficient to amount to damages for the purposes of Section 21C of the Act. The MVDT held that the damage was consistent with ordinary wear and tear. Now, I would say that the 2,700 kilometres would be ordinary wear and tear, but carelessly driving a motor vehicle into a movable object is not. Now, facts arising from the District Court appeal. And that's page 8. Submissions. So the ground of appeal set out in the applicant's notice of appeal is that decision of the MVDT is altered via Section 21C of the Act. On the 7th of January, the applicant filed an application to reduce fresh evidence of these photographs taken 21 of October, and that was granted, declined, but then later granted by Palmer. And on the 29th of June, Judge Harrison dismissed the applicant's appeal. Page 10 of the submissions go on to the relevant statutory provisions. I believe sections 18, 7, 8 have all been discussed at length, and the key to this court is section 21C. We keep coming back to that. We then get to challenges to factual findings. At page 14. Sorry, page 13, relevant legal principles. Commerce Commission and Frontier Cooperative Group Limited held, and it goes back to the meaning of an enactment must be ascertained from its text and in light of its purpose. Your Honour, we've already discussed the text itself on the strict wording of section 21C, and we've also discussed the light of its purpose, which is the same purpose as the Fair Trading Act, according to Justice Elias in McBride Streetcars, to protect consumers and facilitate business, but not protect careless consumers. In TV NZ viewers, the Court of Appeal cautioned that the statute cannot be interpreted to permit unreasonable applications. In this case, again, it comes back to the elasticity of the wording. Parliament were elected and they didn't put minor in front of the word damage in section 21C. There's also reference to one of your honours cases, Rangitonga and Parker, where at 44, the alternate approach advanced by the appellant would not appear to be consistent with policy goals of the legislation and likely to lead to undesirable outcomes. And again, we're trying, when the CGA was implemented, we were harmonising laws with the CER. There's many acts in Australia that are identical here. The Consumer Credit Contracts and Finance Act is identical to the UCCCFA in Australia. as is this provision in the CGA. Also in Rangitonga, the approach advanced by the appellant could involve the unattractive prospect that offending which is merely incidental to the charge upon which the defendant is acquitted could not later be subject to prosecution. Again, that would be an unwanted policy or purpose. Right. Interpretation should support a common sense and practical approach to the section, and certainty is a paramount consideration in commercial cases. Now, here we've been referred to Contract Pacific Limited and Commissioner of Inland Revenue at paragraph 30. On the clear wording of the section, we can see no escape from the conclusions, with other key words there. And at Partono against Ministry of Primary Industries, involving the crew of 3 foreign fishing vessels in New Zealand, unpaid wages of crew members. Interpretation is a paramount consideration in commercial cases. However, adherence to interpretive certainty does not justify the court taking a rigid approach when justice cries out to recognise the plight of the crew members. This is especially so where the reasons for the plight are weighty and not of their own making. Indeed, quite the opposite. This situation is not because of Mr. Murphy's own making. Mr. Murphy and Joden Finance didn't crash that vehicle. Joden Finance didn't cause the damage. Parliament would expressly say so if it intended it to set up 2 materially different consequences in a statutory provision. A statute should be interpreted in a realistic and practical way in order to make it work. Strange interpretation should be avoided. And here we come back to the elasticity of Section 21C. And there's 2 parts to this section: damage, and then how did that damage arise? And that's where the judicial discretion comes in. How did the damage arise? It wasn't related to Joden. And that's the simple, certain and clear interpretation. There is no justification for dissonance. In Manukau City against Ports of Auckland, at 13, and I think that's in our casebook here, Lord Cook said, had that been the intention of Parliament, it would have said so in unequivocal terms. And
I'm reasonably familiar with the legal principles, so perhaps, given you've got about 15 minutes left, it perhaps might be good to move on to about 16 and tackle the substantive submissions.
Right, substantive submissions are on the right page, isn't it?
Paragraph 31.
Paragraph 31. Oh, yes, I
To some extent, I think you've already covered part of this in dealing with the legal principles on it.
Yes. First ground, error of law, interpretation of section 21C of the Act. Your Honour has absolutely correctly identified that we keep coming back to this and drumming it home. That once damage is a material fact, admitted in the tribunal, throughout it, everyone knows who did the damage. The only judicial question after that was, did the original commission of the car cause that damage? And it didn't. And there's a host of Australian cases we've included in there which show how the Australians come to that. There's Dante, the stallion that was gelded, not properly, as it turned out, and caused havoc. That was the Australian jurors took that back and tied it to the original damage. The horse was always damaged. There's also LS&H holdings in these submissions. Again, all these cases have been interpreted correctly on the exact same section as we have. The plain wording of the section is only qualified by two parameters: whether the goods were damaged after delivery to the consumer and that the damage was not related to the condition of the goods at the time of the supply. It follows that damage arising after delivery to the consumer that arises because of the stable condition of the vehicle at the time of supply does not result in loss of the right to rejection under section 21C. It also follows that if the damage arising after delivery has no nexus to the stable condition of the goods at the time of supply, the right of rejection is lost. And that word nexus, that's the key for the Australians, and it's the key for us. Of particular significance is the Parliament has not expressly said that there is an additional qualifier to section 20 pertaining to an evaluation of the extent of the damage to the goods in circumstances where it is established on the evidence that the damage is caused after supply. There is no evidence that damage is caused on the supply. It is submitted that such an omission is intentional. That is because attempting to define and quantify a damage threshold on a product-by-product, case-by-case basis would not be workable, and it would not cause harmonisation across the Tasman. Each good would require a fact-specific assessment of damage supported by an objective evidence-based quantified evaluation of loss of value to the good or the cost of the repair, measured against an unknown threshold of what was significantly enough damage to engage. This way would be contrary to the principle that there would be certainty in the law, particularly in the commercial context. If we're going to quantify damage, then the court needs to appraise itself or make inquiry as to that damage. Before it can say it's minor damage, there was no inquiry. Evaluating the section in light of the broader purpose of the Act, Section 1A recognises the need to protect consumers as well as the need of business to compete effectively, and the need for consumers and businesses to participate confidently. Section 1A2 of the Act provides consumers have guarantees that goods are reasonably safe for the purpose and are of acceptable quality, while Section 1A3 provides that consumers have a right of redress when suppliers fail to comply with those guarantees. Losing the right to reject goods under Section 21C in circumstances where the damage is caused after delivery to the consumer not related to a stable condition at the time of supply does not undermine the Act's purpose. That is because the purpose of consumer protection and a remedy when a breach of consumer guarantee under the Act is found is not lost by interpreting Section 21C in this way. It is only the right to reject that is lost. The consumer still has other remedies available. Now, We've referred the court to prior district court judgments that have come down and used what is defined as the harsh approach. But we would submit those are the correct approach, as in Wright and Fortis Panmure Limited, Mitchell and Trading Post Limited, Poe and Harvey, and they're referred to at page 40 of the submissions, and footnotes 57, 59. Mitchell and Trading Post. Now, Mitchell and Trading Post is an interesting. Mitchell and Trading Post involved scratched the front bumper. Minor. But again, it was harsh. The approach document was harsh. At some point in time, the NPDT has changed and started making law that they weren't elected to. Now, no, we're looking for Mitchell and Trading. I think the best description of jurors on this particular section is discussed in LSH, Auto, Sydney and Sherman, where there is a reasonably in-depth analysis on why Section 2621C of the Australian Act provides a statute bar for the right of objection in the same way as Section 21C, and the available avenues for judicial decision makers. And again, we've included Barton and Bridgman, where the court presented that if Section 2621C of the Australian Act was read down in the way it resulted, then the loss of the right of objection, whatever the damage, that does not leave the consumer without a remedy again. The Australians are saying the same as they are here. There's still other remedies out there. Other Australian authorities we've included are Pate and Niche Holdings, Ross and Hereford. Further New Zealand authorities do not really assist at present because those cases deal with a fluxion of time. They're all temporal based. As, interestingly, were the Saskatchewan cases that we looked at. So the thrust of the above is just to emphasise that the only wiggle room to allow rejection of damage under Section 21C is to tie damage caused after supply with damage arising from damage that existed at the time of supply. Otherwise, damage caused after supply, not related to a state or condition at the time of supply, will result in the loss of right of rejection. We'd also question Harrison's definition of damage. His Honour flipped to the Oxford Dictionary and chose one of 7 different available definitions, which damage could mean any one of those definitions, not just the particular one that you liked on the day. Damage can mean any harm whatsoever. Section 50 of the submission, it is submitted that the interpretation we offered today is clear, certain, workable and fair when considered in light of the Act's purpose. And that the interpretation given by His Honour Harrison DCJ was an error of law and should be quashed. Getting on to the second, error of fact, failure to consider facts, and misrepresentation of facts. The argument is fourfold. Harrison erred in holding the NDT decision. that the damage caused to the vehicle's wheel was minor. It wasn't minor. 2, that the damage to the vehicle was in fact more significant than to the vehicle's wheel. We've established that with the photos today. 3, that Harrison DCJ erred by failing to take into consideration the more significant damage, which we've highlighted today. And 4, that Mr. Preslip misrepresented, withheld material facts from the NBDT and Harrison DCJ in impugning those decisions. Relevant to this ground is the function of an appeal under Clause 16 of Schedule 1 of the Motor Vehicle Sales Act 2003, which provides for appeals where the claim exceeds $12,500. The appeal may be brought against the NBDT's decision on the basis that the decision was wrong in fact or more or both. The applicant's appeal was brought on both grounds, and I understand that is something that Your Honour will determine. The notice of appeal asserted an error of law for being ultra vires, Section 21C, and that damage, a question of fact, invalidated the right of restriction. The applicant says further that Harrison and DCJ dismissed the application on the basis of a misapprehension of a comment made by its director, Mr. Murphy. The applicant asserts that at all material times he intended the appeal to be progressed on both questions of law and questions of fact. The applicant further says the question of law raised was contingent on factual determinations in the dispute. And that's what I said at the outset of my submissions. Error of law can involve error of fact. Next we go on to minor damage of the wheel. The NBDT found that the damage to the wheel was minor and consistent with ordinary wear and tear, such that the right of rejection was not lost. And we look at Mr. Preslip's evidence on this point. It was too dark, so I hit the footpath, the wheel, the car got flat tyre. I mean, the wheel hit and the car got flat at the same time, so I would get the spare wheel. And then earlier on, Mr. Preslip, we'd already discussed this, was he refers to sometimes when we don't know how many times he's hit the curb in this vehicle. Sometime could be more, or it could, how many times? It's a question mark. From Mr. Preslip's evidence, it can be inferred that the impact to the curb was significant by virtue of the evidence. The impact immediately burst the tyre, causing it to go flat. Furthermore, the damage to the wheel was not on the facts wear and tear, rather it was damage caused to the vehicle by Mr. Preslip's careless driving. It was a minor motor vehicle accident, but the damage was not minor. Nor is there any ability for the NBDT to invoke the word minor. The NBDT was wrong to rely exclusively on the photographs provided by Mr. Preslip to assess the extent of the damage. It could and should have exercised its powers under Clause 9C3 of Schedule 1, as it has in other cases, and made its own investigations. I understand that the practice used to be that the NBD inspector would actually just go downstairs and have a look at the vehicle during the hearing if needed. That could have been done in this instance if the NBDT was going to make an assessment of damage. The NBT insisted Joden paid for the car before it brought it back to inspect that damage. It just seems a little bit illogical. So the evidence before this court is that the damage caused to the wheel, which can be repaired, and tyre, which needs replacing, totals $1,204, excluding GST. Significant damage to a vehicle with a purchase price of $14,995. It's submitted that Harrison DCJ was wrong to engage with this issue. It was material to a question of law being decided upon in circumstances where the question hinged on factual determinations that ought not to have been ignored. Both the MVDT and Harrison DCJ failed to take reasonable steps to inform themselves, which is a viewable error of law. Furthermore, the issue was material to the outcome of the appeal, such that the 30th of June decision ought to be quashed and remitted back for further determination in light of this court's judgment. Now we move on to the more significant damage and failures to take into consideration. This is why we have Joden has adduced fresh evidence that was disallowed. The fresh evidence for the court is summarised to include damage to a front left indicator lens, 2 rear brake lights, and the front and rear bumpers.
Okay, I've got that, that's 63.
Yeah, that's where we're at. So 4,300 excluding GST. And the thrust of the submission is that actually, well, the damages equate to about a third of the cost of that motor vehicle.
Okay, should we wrap up? I think we're...
Yes, and lastly, misrepresentation of facts. It is submitted that a significant aspect of the proceeding that cannot be overlooked is that there is incontrovertible and unchallenged evidence before this court that Mr. Preslett misrepresented the extent of the damage to the vehicle, to the MVDT. As the extent of the damage to the vehicle was central to the remedy that Mr. Preslett obtained, the misrepresentation also impugns upon the Auckland District Court decision that upheld the MVDT decision. The interests of justice require the intervention of this court to remedy that outcome. And lastly, unreasonableness. Basically, 68, Mr. Preslett's parking accident, or accidents, if we go back to the transcript, possibly accidents, is clearly inconsistent with ordinary wear and tear. The applicant submits the motor vehicle accidents very clearly fall out of normal range of use. Driving into a concrete object is not a normal use of a motor vehicle. Concluding to the contrary is not within the limits of reason. No reasonable body of persons could have arrived at the conclusion that damage caused by a motor vehicle accident is consistent with ordinary wear and tear. It follows that the MVTC's finding on this point was irrational, and by that implication of that, unreasonable. It is submitted that it also follows that Harrison DCJ's decision is unreasonable for upholding the proof from the poison free. Now I have paragraph 71, I just hope you can always read that. And that would be my conclusion.
Great, thank you for that. Madam Registrar, what's happening? This is where I am.
Thank you. Your Honor, I'd like to begin at paragraph 7 of counsel's submission, where I will would like to address the court briefly regarding some principles on judicial review. The High Court has inherent powers of judicial review to exercise public opinion and ensure they are made according to law. Judicial review, however, is not an opportunity for disgruntled litigants to simply re-argue their case. Where a decision of an appellate court is being reviewed, the disputable issues will usually be very narrowly defined. It is inappropriate on the judicial review proceedings to allow a plaintiff to have a de novo hearing. Your Honor, the applicant please review on the basis of 3 grounds. The first is error of law. A wrong interpretation of the law which materially affects the decision can form the basis of a challenge for judicial review. If the decision is made on an incorrect finding of the law, it is incumbent on the court to rectify that. However, judicial review for an error of law cannot be used to disturb the district court's factual findings. Now, I'd like to refer to the case of McBride Street Cars Limited in District Court at Geneva. This is at tab 3 of the fundamental authorities filed by the second respondent. Probably the smallest of all the bundles on the nature. And all the bundles got 3 pages. 8, 9, and 10. Oh, right. My apologies. This one should have 9 tabs, and we're looking at the third one. Okay, got that. McBride Street Cars is also a judicial review of a district court appeal of a motor vehicle dispute appeal decision. In this case, McBride Street has sought judicial review on the ground of error of law. In that case, the district court on appeal upheld the finding that the motor vehicle disputes tribunal that McBride breached Section 9 of the Fair Trading Act and engaged in misleading and deceptive conduct. If I can refer you to page 297. At paragraph 31 of the decision. And the court there says, the sole ground of review is that the district court erred in law in finding there was a duty on McBride to dispose the statutory right of the vehicle. This is clearly a justiciable issue. If the decision was made on an incorrect finding of law, it is incumbent on this court to rectify that. However, some of the points relied upon by McBride in support of its argument are essentially challenging settled findings of fact, and it is not for this court on judicial review to allow such re-litigation, nor disturb the conclusions of the district court on such facts. There may be exceptional circumstances where a clear mistake has been made, which requires a remedy, but no such mistake is here asserted by either party. So in this case, Your Honour, the court reviewed the facts upon which the decision was made, and these facts were not in dispute. And then it undertook a statutory interpretation exercise. The court looked at Section 9 of the Fair Trading Act, considered the case law, and it framed the legal question that was asked of the court on review. So turn to paragraph 59. The court said in this case, the question before the district court was whether in the particular circumstances there was misleading or deceptive conduct by McBride. Then, Your Honour, the court went on to ask whether it was open to the district court to make certain findings regarding Section 9 of the Fair Trading Act in the circumstances. And in the McBride case, Your Honour, the judicial review was dismissed, and it found that the district court was open to make the findings that it did. Now, Your Honour, I'll come back to using the framework for analysis of error of law in this way and in application to these facts in this case. In relation to these grounds in this case. Your Honour. I do think it is a helpful case to provide a framework on which to work from. The second ground for review is error of fact. The decision maker must have the correct facts, and those facts must logically support the decision. However, a mistake of fact does not apply as a basis for judicial review when there is one or more viewing facts that can be reasonably held. The court has also noted in relation to specialist tribunals that reasoning and conclusions on the material should not be revisited an alternative conclusion substituted unless there are strong and highly persuasive reasons to do so. So, in the context of judicial review, Your Honour, error of fact is, for example, where it can be established that there is a lack of evidence supporting a finding of fact, that the decision is based on inadequate fact, that the decision maker has ignored or disregarded an incontrovertible fact, or as referred to in the McBride case, sometimes in exceptional circumstances, there might be a clear mistake of fact which requires a remedy. And the final ground, Your Honour, is for review has pleaded as unreasonable. Your Honour, turning to paragraph 14 of Council's submission, I would like to touch on the fact that in these particular circumstances, appeal from the District Court is not available through parliamentary intention. So Section 16 of the Schedule 1 of the Motor Vehicle Sales Act 2003 states in the decision of the District Court on appeal on the tribunal is final. However, the right to apply for a judicial review is specifically preserved. In light of the specific prohibition regarding further appeals, Council submits it's particularly important to consider the differences between an appeal and a review. A review is concerned with the legality of the decision, addressing the process and procedures of the decision making. Council submits the court must be very careful to confine the grounds of review to just that, and not to broaden any issues to a scope which might be more relevant for an appeal. Turning now to the first ground regarding error of law, Your Honour. The decision of Judge Harrison regarding the interpretation of Section 21C is set out in paragraphs 20 through 26 there, and I've also repeated those in my submissions. I think that is quite important, and I would like to read that out. At 20, Judge Harrison states, the issue, it seems to me, is whether the right to reject a vehicle is lost of any damage, even of the slightest imaginable, such as a scratch to the paintwork, to justify the finding the right of rejection is lost. I do not accept that the legislature intended the effect of Section 21C to be so harsh. Damage is defined in the new short Oxford Dictionary as loss or detriment to one's property, reputation, etc. 2. Harm done to a thing or physical injury impairing value or usefulness. At paragraph 22, he goes on, it must be remembered that the right of rejection only arises after a finding pursuant to the Consumer Guarantees Act that the vehicle supplied had faults that breached the acceptable quality guarantee, and that those faults amounted to a failure of substantial character. I cannot imagine that the right to reject a vehicle is lost because after purchase insignificant damage may have been caused to the vehicle. In my view, it must be established on the evidence that the damage impairs the value of the vehicle to the extent that it would be unconscionable to permit the purchaser to reject it. That will be a question of fact for the tribunal in each case. And then last step 26, there was no challenge to the factual findings of the tribunal. Mr. Murphy's point was that the minor damage identified had to result in the loss of the right of rejection because Section 21C is mandatory in its terms. I do not accept that it is so harsh for the reasons given. The damage relied upon must amount to some loss of value to the vehicle or reasonably significant cost of repair, justifying the finding that damage greater than fair wear and tear has occurred. It is Council's submission that Judge Harrison did not err with regards to his interpretation of the relevant law. He correctly identified the court's task regarding the interpretation of the Act. Submissions filed prior to the appeal hearing for both the appellant and the respondent supported the question of law as framed by the judge. And then you can refer to those submissions in the common bundle. Judge Harrison engaged with the context of the legislation, and it is submitted the applicant is unable to show the judge harbored any misunderstanding of the legislation for the purposes of the appeal. The judge considered the case law regarding previous tribunal decisions and a dictionary definition of damage. After taking into account these usual considerations in the course of the statutory interpretation exercise, Judge Harrison upheld the interpretation in the tribunal and concluded in order for a consumer to lose their right to reject the vehicle, it must be established on the evidence that the damage impaired the vehicle, so the value of the vehicle to the extent that it would be unconscionable to permit the purchaser to reject it. Counsel submits that this conclusion is consistent with the case law and one that was clearly open to the district court to make on the facts that were accepted by the appellant. Applying the methodology in the McBride Street case, the judge followed exactly that same process. He reviewed Section 21A of the Consumer Guarantees Act, considered the case law, framed the legal question, and reached a finding that was open for the district court to make. This is an uncontroversial decision that does not reach the threshold for an error of law. Remembering that judicial review for this ground cannot be used to disturb the district court's factual finding. It is counsel's submission that the applicant's submission regarding the interpretation of Section 21A and that it's mandatory in its terms was the exact argument that was put before Judge Harrison in the appeal. Judge Harrison rejected this argument for clear reasons, and it cannot be a reviewable error of law. Turning now to the grounds of error of fact. The applicant's second ground for review is that Judge Harrison's decision relied on the wrong facts. And now at paragraph 24 of the submission. In part by disallowing the application to admit new evidence. Counsel submits that the crux of this ground in fact appears to be the applicant's assertion that Joden brought the appeal on the grounds of law and fact, and that Judge Harrison erred in his determination to proceed on the basis that the appeal was only on the grounds of law. It is counsel's submission that everything that flowed from that decision is not, in fact, an issue in this judicial review before determining whether that an error occurred at that step in the process. Right? Referring to the applicant's submissions for this hearing, Your Honour, paragraph 52 of the applicant's submissions. Your Honour, the applicant has framed this second round and broken it down into 4 separate sections. The first is that Harrison erred by upholding the tribunal's decision that the damage was caused to the vehicle's wheel was minor. The second, that the damage to the vehicle was in fact more significant. The third, that Judge Harrison erred by failing to admit the evidence essentially. And the fourth, that Mr. Purcell misrepresented or withheld material facts. Your Honour, it's submitted that part 1, 2 and 4 of that paragraph really asserts Judge Harrison made an error of fact by determining that the tribunal's findings regarding those facts, namely the damage, should be upheld. Part 3 of that paragraph is slightly different, Your Honour. There, the applicant's grounds asserts Judge Harrison disregarded relevant facts, namely the fresh evidence of photographs, and that was an error. In counsel's submission, before the court can consider whether a ground of review based on error of fact can proceed, it must carefully identify whether the district court actually made any findings of fact in the appeal. That is, whether facts were a live issue in the appeal. The applicant submits, in counsel's submission, this is the key distinction between the positions of the parties in this review. The applicant submits the appeal in the district court was brought on 2 grounds: that the tribunal was wrong in fact and law. Noting the applicant was at all times represented by its director, counsel submits the notice of appeal is actually ambiguous as to whether the appeal actually includes a ground in relation to the facts. I have repeated the section of the notice of appeal here for Your Honour.
Sorry, read what paragraph you want?
So apologies, on paragraph 28 of counsel's submission. And I'm referring to the notice of appeal that was filed in the district court.
Yes, sorry, yes, got that.
And there, at paragraph 2 of the notice of appeal, the appellant relies on the following grounds: that the decision is a breach of statute law and is therefore ultra vires and nullity, and B, that the vehicle is damaged following delivery, thereby invalidating any rescission application. The counsel submits that the first ground under ground A clearly relates to an interpretation of the law. The second ground is slightly more ambiguous. It could be a reference to an appeal on the facts in relation to the findings of the tribunal regarding the damage. However, it could also be interpreted as supporting the first ground, namely the submission that the law should have been interpreted in a mandatory manner, and the rejection lost as soon as damage was found.
I mean, your second interpretation seems the more logical one, I would have thought, just because it says relies on the following grounds. The decision is in breach of statute law and is therefore ultra vires and a nullity, and that's the argument that Section 20C means that if there's any damage, then you must, you lose your right of rejection. And then B, that the vehicle was damaged following delivery, thereby invalidating any rescission application. That's kind of, if I'm right on the law, then the vehicle was damaged and therefore the right to reject had been lost. So really they're both limbs of an error of law argument, because there's actually, as I understand it, there's B isn't an issue in dispute because it's clear the vehicle was damaged. I mean, it was found to have been damaged by hitting the curb. So that's actually not, he's not appealing against that finding of the tribunal, because if the tribunal had found the vehicle was not damaged at all, then you might appeal and say, well, actually the vehicle was damaged. But in fact, the tribunal found that the vehicle was damaged, and Mr. Preslip admitted that the vehicle was damaged. So I would interpret that as both those limbs actually relate to the error of law, because he doesn't need to appeal about the damage, because that's actually common ground between the parties. And he's not raising an issue there about the extent of the damage, because his argument is that it doesn't matter what the extent of the damage is. So in the district court anyway, his argument is it's irrelevant what the extent of the damage is. Any damage precludes a right of rejection. So I struggle with the proposition that B is raising an error of fact, because what would the error of fact be? He's not. They've said the vehicle was damaged, and he's agreeing with that. So I can't. It could only be an error of fact. I would have thought if the tribunal said the vehicle wasn't damaged.
Your Honour, you've hit the nail on the head, And that is how Judge Harrison proceeded. Council's submissions were simply trying to, I suppose, be slightly generous to the interpretation of the notice of appeal. However, that was simply not the way the case was presented in the district court. It was presented on the basis of an error of law. That was how the papers were presented, and that was how the submissions were presented. And the rest, the following paragraphs in my submissions go through those in some detail. It wasn't until the interlocutory application was made where it has to be considered on the face of it, applying to adduce further evidence in relation to damage. Judge Harrison then clearly became alive to the possibility that the appellant's case may be more than just a ground of appeal of law. But His Honour, Judge Harrison clearly discussed that with the appellant because his decisions refer to that fact. They refer to that is not Mr. Murphy's case now. They refer to the very live possibility that that could have been relevant evidence for a ground of appeal on fact. But His Honour, Judge Harrison says, but that is not the case here. So there was clearly a process that Judge Harrison followed in reviewing what was being presented to him. If there was an appeal on the ground of fact at all live before that point, in council's submission by this stage it had been abandoned. However, there is nothing else on the paperwork apart from one section in the appellant's submissions before the interlocutory hearing that refers to any dispute on the facts. So, Your Honour, the question is not should the appeal have been run differently, should the appeal have included a two-pronged attack. That cannot be a reviewable ground. Perhaps it should have been run that way, but that is not a ground for review, judicial review. We have to be very careful here to narrow the grounds to what is appropriate and lawful to maintain a judicial review. This is not an appeal. It cannot be another appeal that has been specifically prohibited by Parliament in this case. So, Your Honour, turning to paragraph 36 of my submission, we've just, in essence, covered this matter, but Council has to concede that the fact that new evidence was being sought in the district appeal to be introduced must have led the court to be alive as to whether there was a second ground of appeal in relation to the factual determinations of the tribunal. However, after careful inquiries were made of the applicant as to the grounds of the appeal, Judge Harrison found there was no basis to admit the evidence. And he says in Mr. Murphy's case today that the decision was wrong and the appeal should proceed on that basis. And he specifically alludes to the fact that on the face of it, further evidence may be relevant to the right of the petitioner to reject the vehicle. However, Mr. Murphy says that is not his case. His case is that the tribunal's decision as it stands is wrong by reasons of the findings that the damage referred to is insufficient to warrant an application of Section 21C of the Act. So it's Council's submission that Judge Harrison ascertained the crux of the appeal in a perfectly orthodox way and proceeded to make his decision in relation to the interlocutory appeal on that interlocutory application on that basis. Turning to 38 of paragraph 38 of my submission, at the substantive appeal, the applicant restated its grounds for appeal, restricting again the appeal to the interpretation of the Act. No argument was made in relation to the type and nature of the damage that had occurred to the vehicle or the tribunal's findings in that regard. Judge Harrison issued his decision in relation to the substantive appeal on 30 June 2020. He noted the jurisdiction for bringing appeals included grounds that the tribunal is wrong in fact or law, or both facts and law, and that he did not understand Mr. Murphy to challenge the tribunal's findings of fact. And Judge Harrison concludes at paragraph 26 of his decision, there was no challenge to the factual findings of the tribunal. Paragraph 27, it is not the case here according to the tribunal's findings of fact. It is not otherwise misinterpreted in law, and as a consequence the appeal is dismissed. So, Your Honour, the applicant has now framed its position for review conveniently in the alternative, that any damage causes a loss of the right to protect, but in the alternative, that the damage was actually more serious than the tribunal found. The applicant says that the district court was wrong to exclude the fresh evidence, and that is a ground for the review on the basis of error of fact. He says that Judge Harrison dismissed the application to adduce the photographs on the basis of a misapprehension of a comment made by Mr. Murphy, and that in fact at all times the applicant intended the appeal to be progressed on both the question of law and fact. With respect, this simply was not how the applicant presented its appeal in the district court. It is counsel's submission that the applicant's assertion both grounds for appeal were alive is simply not supported by the evidence, and the district court made no such misapprehension. The applicant made decisions as to how it ran its case on appeal in the district court. It cannot now rerun its appeal through the back door of a judicial review process. The applicant's assertion that Judge Harrison had erred in upholding the tribunal's findings that the damage was minor and that this amounts to an error of fact has to be flawed in counsel's submission. Judge Harrison did not uphold the tribunal's findings in relation to the factual issues because those matters were not challenged and they were not a live issue before the court. It follows in counsel's submission that when considering the material before the district court, the applicant's own presentation of its case on appeal, it is submitted the applicant can now raise a ground for review which relates to the error of fact. Paragraph 47 of counsel's submission, Your Honour. Any submission that an appeal on the facts was and should have been a ground for the district court, counsel submits amounts to an assertion that Judge Harrison willfully ignored or disregarded the ground of facts for an appeal. Such an assertion of bias is an extremely high bar, and counsel submits it cannot be met on the evidence before the court. Given the appeal's own limitations in the district court, the only question on judicial review in relation to this ground is whether it was properly open to Judge Harrison to conclude the appeal was only to relate to an interpretation of the law. Justice Palmer has admitted the further evidence of Mr. Murphy's photographs for the purpose of this review. It is counsel's submission that this purpose is to provide context for Judge Harrison's decision in the interlocutory proceeding. The veracity of that evidence as against the tribunal's findings, that is, whether it can be argued the photographs show further or different damage to the findings of the tribunal, cannot be a proper purpose given the context of judicial review. The sections of the applicant's submissions that refer to analysis of the so-called parking mishap and damage to the vehicle the amount of damage, the type of damage, and the tribunal's findings, simply not relevant to judicial review and broadens the issues beyond this court, beyond review. There was a final ground that the applicant pleaded unreasonableness. And I've set out brief submissions in my submissions at paragraph 50 and 51. So to conclude, Your Honour, Council submits that the grounds for judicial review need to be carefully considered in cases such as these and are usually narrow. The applicant has failed to show the district court, being in law, all was unreasonable in its decision. Judge Harrison's decision for both the interlocutory hearing and the substantive appeal provide clear reasons and are supported by the documents before the court. The applicant can now raise matters that more properly fall within grounds for a second appeal. It is submitted there are no grounds to review based on an area of fact, as these matters were not an issue before the district court. Reverting to the core principles of judicial review, Council submits there are reasonable grounds for Judge Harrison's decision. His decision was measured, reasonable, and uncontroversial, and there are no grounds for the court to intervene. Unless you have any questions, those are my questions.
Thank you, Mrs. Brown. Mr. Beard, okay?
Just going to the notice of appeal, paragraph 2b on page 9 of my building friends submissions, and Your Honour's comments about the second ground being I merely read there that the vehicle was damaged. It doesn't say whether it was the parking incident or what incident. It was just damaged. It doesn't go any further or specify.
Yeah. And that wasn't a dispute.
Yeah.
I mean, that's not factual. I mean, he's not appealing a finding, for example, that he's accepted the factual findings of the tribunal, which included that the vehicle was damaged. So the argument, as I read it, is that the tribunal's misinterpreted the law because the law says if the vehicle's damaged, you lose your right of objection. Here, the vehicle was damaged, so necessarily follows he must have lost the right of rejection. And it's not a dispute that the vehicle's damaged. It's common ground that the vehicle's damaged.
Yes, Your Honour. All I'm saying is you add the lights and the bumpers and with that damage referred to at 2B, and then you get your factual.
But he didn't run in the district court what I put to you, I think, at the outset as the alternative argument you could have run. So you could have run an argument on appeal. They've erred in law, and any damage whatsoever precludes right of review. But if I'm wrong on that, then the level of damage here was exceeded what was reasonable, and therefore, but he didn't run that second argument in the district court.
But
He only ran the first argument.
But section 2B would be wide enough to encompass that.
Well, section 2B, he's just saying the vehicle was damaged, which is not actually in dispute. But it needs to be there to win your appeal, because your appeal is basically A, they've got the law wrong, and in fact any right of damage precludes right of rejection. B, it exceeds that threshold because the vehicle was damaged and it's not disputed it was damaged, thereby invalidating any recession application. There's nothing in the submissions or the notice of appeal or the judgment that suggests that he ran an alternative argument that said, if I'm wrong on the law and there is a right, you only lose the right to reject if the damage exceeds ordinary wear and tear, then I'm saying that the damage was greater than what the tribunal found. He's accepting the tribunal's factual finding and just running a pure legal argument. That's how I read what happened in the district court.
As Your Honour pleases, I would say that a lay litigant prepared that Part B, so I would be generous with my interpretation of that.
Well, I think though it's not just that, is it? It's looking also at the substantive decision, the decision on adducing further evidence, the transcript of the hearing. Look at all those things. You can see whether he in fact did run an argument in that court. The fallback argument, which you're right, which a lawyer might run, which is, if I'm wrong on the law, then I run a factual argument that the tribunal was actually wrong about the extent of damage and it exceeded ordinary wear and tear. But in fact, as I read things, he accepted the tribunal's factual findings and said, well, based on those factual findings, it's common ground that there's damage, and if you accept my interpretation of the law, then he's lost his right to reject. But anyway, I mean, I'll go back through the transcript again and have a look and see if there's anything in there which might suggest that he did flag that alternative argument, which he's really advancing in this judicial review.
Yes, all I was reiterating was the could-be factor referred to in paragraph 13. Now, just in summation, the tribunal ruled that Joden would pay for the car before Joden could appraise the vehicle and find out the extent of damage, whether it was minor, major, or any qualifier. Joden asked on many occasions to appraise the vehicle before the hearing, before it was called upon to pay, but that was denied consistently until Mr. Prislip's lawyer granted access. And then when we did get the evidence, it was denied in the district court, despite Judge Harrison's noting that it may be relevant. Mr. Prislip has never denied that Mr. Murphy's affidavit evidence showing the significant damage is incorrect, and Joden submits that Mr. Prislip has not come to court with clean hands in terms of the damage to this motor vehicle. And that's
Okay, well, thank you both, counsel. I'll reserve my decision on that. Thank you both for your submissions, and I will deliver that through the registry in the usual way. It's unlikely to be court finishes up Friday next week, and I'm duty judge next week.
I might point out right here that nowhere during this hearing, nowhere during this hearing was I mentioned as being at the June hearing as a support person for John. And this comes into play very, very well, because after this court case, I have the decision made by old Sarah Katz. And she never wrote that, because they pay particular attention to the fact that I was also a support person in June for John. No, I wasn't. I was never introduced as that whatsoever. I was there in the back of the courtroom just observing. So, receiving information in any form I saw fit. Gary didn't even know I was in the back of the courtroom. So, but for some reason, that's written about in the judicial decision. So this shows just how ridiculously stupid. Right, as far as I'm concerned, John should just do a judicial decision on the initial tribunal's findings, because they found that it was due to ordinary wear and tear when they're fuck-ass wrong. And one thing they missed out on doing is actually looking at the vehicle. Other times John's been through the MVDT, they've come down and checked the vehicle. This time they didn't. And how the hell did Mr. Prislip keep getting legal aid funded by you and I to do this? Talk about the court system making money out of you lot.